So today's presentation, protecting brands in a digital world. Bottom line is we're all online most of the day anymore. And the majority of brand protection needs to take place in a digital environment. So before I get into it, just a little bit about who we are, who I am. My firm is Gerben Perot. My law partner, Eric Perot, is not joining us today. If you've been on these calls before, you're familiar with Eric. He escaped to the Reno, Nevada this week for a board game conference. Of all things, board games, they have a whole conference around it, although I guess every industry has a conference these days. But very interesting stuff. Eric is a board game aficionado and works with a lot of clients, actually. I mean, every board game has a trademark, the name of the board game. So he works with a lot of board game clients, and that's a passion of his. So he's out there and not joining us today. So I could probably say anything I want about him today, but I'll hold back for the most part. Our firm is celebrating our 15-year anniversary just in March. So I started the firm in 2008 at the ripe old age of 27. We are now in our 15th year, and we now have 8 lawyers. Courtesy of the pandemic, we're spread out a little bit. We have a bunch in Washington, D.C. I myself are located outside Philadelphia and Pennsylvania. Florida, Vermont, and Nashville make up the rest of the crew. Our firm is heavily focused on trademark law. We really don't do much else. Over the last 15 years, we've successfully registered over 7,500 trademarks for clients in the US and also in countries around the world. So trademark practice is really cool in that you not only get to work in the United States, but you get to assist clients in protecting brands internationally, which we will talk a little bit about today. Our firm's also settled over 300 disputes without the need for significant litigation, which to me is a point of pride with our clients, that we don't have to engage in very significant litigation that often. We've overcome a whole host of USPTO refusals on our attempts to register marks for clients, and we've successfully resolved a lot of trademark trial and appeal board cases, which is the administrative court within the USPTO. So that's a little bit about us, and just, I always joke, but if there's anything about trademarks, I probably know about it. If it's anything that's not about trademarks, I probably know nothing about it. So hopefully I will be helpful today. And as we go through the presentation, please feel free to ask any questions. I'm more than happy to take your questions as we go. Matter of fact, I prefer that you're asking questions throughout the presentation, because it gives me a little break from the monotony of whatever my presentation is going to be, and I'm sure other people are thinking the same questions if you have them. Thanks for all the wonderful wishes in the chat. Much appreciated. It's actually really hard to believe that we're 15 years in. It goes so fast, and I always warn people that, man, it starts to really fly by. So enjoy it. All right. As we always do in these presentations, I want to start without any presumptions, so apologies if this is very basic for you, but what is a trademark? Because we're going to talk a lot about them today. A trademark is essentially what is called a source identifier, meaning that it acts as a shortcut for consumers to identify what company they're working with. So if you see Nike on a box, you know you're buying a Nike shoe. If you see a swoosh on a box, you would know you're buying a Nike shoe. So trademarks can be a lot of different things. It can be that logo that you see. It could be a name that you see. And I bet you anything, if I played a certain ta-dum music, you would know that Netflix is coming on your TV, and that, sounds can be a trademark. So anything that consumers use to identify what products are served, what company is behind the products or services being offered, these are trademarks. And whether or not you realize it or not, you're probably interacting with them every hour, if not every minute of every day. And every single company on this planet has a trademark, at least one, its name, and many times has many others. So trademark protection is, again, at the heart of what we do. Here's just some of the examples. Just using Nike, you have Nike, the name, obviously. We've got different products they have, like Nike Shocks. So if you have like product lines, those can be protected as trademarks. Slogans, just do it. Another great example of, if you just hear just do it, you know exactly what company I'm talking about. And one of the cool ones, besides sounds, is this idea of trade dress. So how does a product look, and how does it look? If you have that unique air design on the Nike shoe, Nike has a lot of trade dress filings around the design of its shoes. Also, alcohol makers, you think of like a Maker's Mark bottle with that unique wax cap on it. That's a trade dress. It's a registered trade dress. So all these things can really be protected. And these are also things that are misappropriated by folks, especially in an Amazon and otherwise online world where products can be easily sort of dumped on the marketplace, if you will. So what do we do about protecting all these brands? We can go to the extent of registering all these trademarks for clients, and we get these portfolios set up, and then you run into a problem. If you could see somebody, a lot of times the infringement happens in today's world on a third-party platform, because we have platforms like Amazon, Etsy, eBay, where folks can easily make and sell products. So you don't have to set up your own website. You could just go online and do these things. And that creates a lot of opportunity for infringers to be out there. And this is where a lot of our clients run into problems. So one of the reasons we preach about getting trademarks registered, and one of the reasons that, quite frankly, we have a growing practice, is because this problem continues to grow and be an issue for folks. If you do register a trademark, one of the biggest benefits in today's world is that it allows us to win a fight on a platform's dispute resolution policy and not have to be in court. As I'm sure a lot of you know on this call, the minute we start with filing a complaint in federal court, we're talking about anywhere between $10,000 and $20,000 just to start the process. And it goes from there. So if we're able to register a trademark, which many times can be done for less than $2,000, you can then go and use these third-party platforms' dispute resolution policies to try to get infringing materials down. And it might only take an hour or two of investment of time. It might not be very significant at all. So without that trademark registration in hand, it can be very difficult to deal with these platforms, because if you go to an Etsy and eBay and Amazon and you don't have a trademark registered, very often the response is, well, we don't know who the trademark owner is. And they use the USPTO's database as essentially an arbitrator as to who's the rightful owner of this trademark. And that's because the fundamental law behind trademarks is that when you own a registration for a trademark, you are presumed to be the national owner of that mark. It's a rebuttable presumption, but it is a presumption that you walk into court with. And these companies basically say, well, if you have a presumption of ownership, we're going to essentially treat that as the gospel. We're going to say that you're the trademark owner. So it's in today's world, and this wasn't even, 20 years ago, this wasn't even an issue, but in today's world, when you have these trademark registrations, it really enables you to go on these platforms and police things and keep yourself out of court. And again, sort of the last point on this slide is that this not only applies on the third-party websites I've been mentioning, it also applies in things like search engines and social media. So any trademark registration you can obtain for a client can really, it genuinely saves a lot of money in the long run. I mean, we see it every time, all day long. And so it's something that we just highly recommend. If a company has not invested in the trademark process, sometimes you're like, I don't need this, or I don't understand this. Well, this is one of the big reasons why it really does save money later on. And by the way, I'll add this, it's currently taking anywhere from 12 to 18 months to get a trademark registered once we file it. Very rarely can you even get that expedited. And if you get it expedited, it might save 6 months, but it is a completely backed up and messed up, quite frankly, process at the USPTO. Now they've had a backlog for years. It keeps growing. They're not fixing it. They are very capable of fixing the problem, but have not been very good at executing on any kind of real fix at this point. So we're hoping that they're gonna change, and make better changes, but we're also not terribly optimistic given what we've seen the last few years. So you just have to prepare clients. It's going to take a really long time to get a trademark registered, and the sooner we do it, the sooner we're going to be able to police it on all these platforms. So was just talking a lot about what's on this slide here. Again, the infringement that occurs on these platforms, having the trademark registered being the most effective way to deal with it. and the dispute resolution policies that each platform has. What we're going to do right now is we're going to talk about one of these platforms that most clients are on these days, which is Amazon. Amazon has, so a lot of times, for what it's worth, before Amazon created this, what they call this brand registry, we had situations where we would go to the Etsy's or eBay's or even Amazon's of the world and say, hey, we see these infringing products being sold, and they should be taken down. And sometimes you might not even hear back from them and they would just take it down. Sometimes they would put you in touch with the infringer and be like, work it out. And they'd have all these weird things that you might do. Amazon, because of its growth and scale, started to have an extraordinarily significant problem with counterfeiters and infringement in its marketplace. So it created this thing called the brand registry. The brand registry has taken on a lot of different lives over the years. Meaning there's been all kinds of iterations of it. The current iteration basically makes the brand registry a quasi, or what I would call a shadow trademark register. Because if your client gets a trademark registered with the brand registry, they get all kinds of superpowers on Amazon's system. It's great for brand protection because once you are registered with the brand registry program, essentially you can take down other listings pretty much at will that violate that trademark, and it happens pretty quickly. The bad part about it is it can be used nefariously. Amazon has set it up because the USPTO is taking so long to examine applications. Amazon is allowing folks to get registered in the brand registry without a registration from the PTO. All you need to do is file a trademark application and get a serial number from the PTO. And it makes almost no sense because anybody can file a trademark application on anything. I could file, and then you get a serial number and you can get, with not too much cajoling, get into the brand registry. So I call it a shadow trademark register because they're not actually following what's registered with the USPTO. They're following more or less what has been filed. Now, they can revoke the brand registry status if something happens to your application, but in that interim period, you can still have access to it. So it is quite a unique and odd system at the same time. According to Amazon, this is a quote from Amazon, the Amazon brand registry provides access to powerful tools, including proprietary text and image search, predictive automation based on your reports of suspected intellectual property rights and violations, and increased authority over product listings with your brand name. So you can see what Amazon's trying to do is make sure that genuine products are being sold on its platform. It doesn't have the counterfeit issues. And it's open right now in a variety of countries you can see on your screen. So it's not just in the US, it's in all these other countries. And I'm put a bookmark on that because I'm going to come back to that issue about things that are occurring off of US soil in a moment. But one of the things that I just caution clients about too here is that when what happens is when we file an application, a lot of times we get an email from a client a couple of weeks later saying, hey, I'm trying to get in the brand registry, and you're going to get an email from them. And we basically have to verify with Amazon that this application was filed and that this is the party who they say they are. Again, nothing's been decided about this application. The USPTO hasn't reviewed it, but then Amazon grants this person access to the brand registry. The challenge could be that an individual client may then start to make demands and ask for listings to be removed. And what you should be on the lookout for if you hear your clients talking about this is that if they remove a listing they shouldn't, meaning that they go beyond the rights that they really do have, they can really open themselves up for liability for things like tortious interference with a business relationship, because you're taking somebody else's listing down, by weaponizing essentially a trademark filing, and you shouldn't be able to, you shouldn't do it. It's an improper action. So, while it seems very self-serving for lawyers to tell clients not to do things on their own, and I certainly understand how that sounds, there's really legitimate concerns about the takedown notices that are starting to be thrown around Amazon's system without legal review. And this can sometimes happen with small organizations that just decide that the cost of legal services is too significant. We've also seen it with larger clients. So I'm not going to name them by names on this call, but there are software programs that have been developed to basically scrape through Amazon's product listings and look for infringing product listings to your brand. And then it can automatically, or somewhat automatically, like somebody can be sitting there, it could be a brand manager, it could be some, at the client, it's not a lawyer typically, is deciding what listings to then request be taken down. And there's major companies that are using this kind of software and demanding listings get taken down without any kind of really strong legal review. Again, we're dealing with this sort of cost benefit thing where folks are not looking for a lawyer to review every listing and pay for that. But if you have clients that are using these kind of softwares and doing these mass takedowns, you may want to have at least a top line strategy conversation about whether or not it's a good idea or not, because you could run into a lawsuit that gets filed against your client for an improper takedown notice. And clients really need to be careful about that, because I've even been on calls with clients where it's funny because we'll talk about our takedown procedure and what we're doing with Amazon and how we're vetting the listings we're taking down and things like this. And the question will come up invariably, no offense to the under 35 crowd, but it's never anybody over 35 years old that asks this question, which is there a technology solution for this? So, they want to know, like, why are we paying Josh and his team to go do this? Isn't there a software program that'll just replace these guys? And, yeah, there is, but it comes with risk. And so you have to really balance that and decide on whether or not it's correct or not for your organization or for your client. And a lot of words of caution there. And I just think it's kind of ripe for litigation and for clients to kind of cause problems for themselves.
Hey, Josh, there's a quick question here in the Q&A. Somebody asked, should you trademark your attorney website?
Yeah, well, we certainly have protected our trademark for Gerben and for Gerben Law Firm when we were now Gerben Perot or Gerben IP. But the logo you see in the bottom left-hand corner of your screen is protected with a federal registration, which is why we use the circled R next to it. So I always tell folks that it's a good idea to protect your law firm's name with a trademark registration, because you never know when you're going to have a problem with somebody impersonating you. And we've actually had that issue before where somebody's tried to impersonate us and we've had to do takedowns of our own. It's been on like job posting sites where we've had that happen. We also have had, which I'm going to get to, it's a great question because one of my slides coming up is about enforcement action we've taken around domain registrations that we were worried about. So having a trademark registered for your law firm, you're a business too. And I go back to the bottom line that every single business has one trademark at least, which is your name. And so if you're not protected with a federal registration and something happens, you're kind of caught without much recourse. You're going to be really starting from behind the eight ball. I always give the example of if you're in a car accident and you start to go through the windshield, you can't decide, oh, you know what, I should have had my seatbelt on. Let me go back in time and put it on. If you start to have an infringement and you're going through that windshield, like you can't stop that infringement from occurring. And now you don't have that safety mechanism in place, which is that trademark registration to protect you. And you're going to kind of be out there. There are common law rights and things like that exist, but you're going to have a much harder time dealing with the issue than if you had a registration in place. So great question. Thank you for that.
Josh, we have another question as well. Does Amazon take on liability for trademark takedowns, or does it mostly fall on the party sending the takedown?
Well, there's been some case law about how, or there's been a lot of cases, I should say, about whether Amazon should be liable for products sold, especially from a consumer safety perspective. Like if a product sold on Amazon that hurts somebody, is Amazon liable for having sold that product? So that's one of the reasons this brand registry got very aggressive, in the sense that they're allowing people to police things before there's a registration, because they did have a major problem with counterfeit products that were dangerous. So Amazon is trying like anything it can do to not be liable, saying, hey, look, we're just providing the platform, and it's these sellers and the buyers that you have to, that have to deal with between themselves. But more and more courts have kind of started to poke through that, especially on products where people are getting hurt. And that's one of the reasons Amazon wants to kind of be over enforcing with trademarks. I just think that there's a potential for a lot of litigation against Amazon and parties doing the takedowns, that the system is it is imperfect, and it leaves open a lot of questions as to how legitimate some of the takedowns are, because there's certainly people that weaponize them and use them for competitive purposes. Any other questions, Lacey or Hunter, at this point? No. Okay. Great questions. Thank you so much.
Actually, I will jump in really quick. We have a couple people asking about the sending in their borrowed license number. We will ask you to submit that on an attendance form at the end of the CLE. So you don't have to worry about sending that to us now. Thank you.
Thank you for that, Lacey. So I picked on Amazon long enough, so I'm going to move on. AdWords is another common problem. Google AdWords and any other, it could be, I don't know if anyone uses Bing, although maybe now they do since they've got an AI-driven search in there. But most people call us complaining about AdWords. Search, so essentially what happens in AdWords is, if you type in Nike shoes on Google, you're going to get presented with a lot of ads, right? Because there's going to be people trying to sell you Nike shoes. What competitors have done is, let's say you're Adidas, you might say, well, if someone types in Nike shoes, I know they're looking for shoes, but I want my ad to appear. And they will then show their ad. So they'll bid on the keyword Nike or Nike shoes so that Adidas's ad will show if you're looking for Nike. And there's been a ton of litigation over this because brand owners have said, look, if somebody's looking for me, and I mean, I've seen this, people have typed in Gerben Law Firm and there's ads that appear that are not us, they're for other trademark lawyers. So it always kind of gets my goat. But anyhow, if so, imagine you own a business and you Google it, and then your competitor comes up at the very top because they're buying the ad on your keyword. Well, everyone's suing Google over that. Like, what the heck? That's confusion, right? I'm looking for Nike. You're showing me Adidas. That is classic confusion, right? You're trying to confuse consumers into going on their site. People think if they're looking for Nike, all they're going to see is Nike results. Well, courts have sided with Google. This is big business for Google. This is a lot of money on these. Every time you click on one of those ads on Google, you will not begin to believe what Google's making, although maybe you will, given the size of the company. But they make a lot of money on these ads. So they've had a lot of impetus to defend this practice. And they've been very successful. And I think courts are just dead wrong on this issue. I couldn't disagree more. And but nevertheless, this is what the law is, and I don't get to make the laws. So essentially, if your client calls you complaining that somebody is buying a keyword and their ad is showing up when they Google themselves, there is literally nothing you can do about it. The only thing you can tell your client is, well, you need to now have an ad that comes up when someone Googles your name, you can appear first, right? Because you're going to pay for that traffic now. And this is how, again, this is how Google makes money. So if I want Gerben Perot to come up before every other trademark lawyer, when someone's Googling Gerben or Gerben Law Firm or whatever, I got to pay for that. And that's why sometimes you'll see official, whatever site, because people are saying, hey, look, you're going to see a lot of stuff in these ads that is not our company when you were looking for our company, and this is the official site. And I wish somebody would make better arguments to a court somewhere and we get all this case law overturned, but we're probably in pretty deep at this point. The one thing you can do is that if a competitor is using your client's trademark in an ad text, in the ad copy itself, now you can complain and get that ad removed or banned from the system, and you could start to create problems for your competitor. Also, that's actionable. You could sue. You could file a lawsuit if you want. So those are what you're really looking for is the trademark appearing in the competitor's ad. So if it was Adidas's ad and it says, looking for Nike shoes, ? How about Adidas? That could, there's a fair use argument there, but you would also have a really good argument that it's an improper use of the trademark. So those are the types of things you need to be on the lookout for. And unfortunately, clients are going to waste a lot of money if they start arguing about what's triggering the ads. Any questions on that? The next topic is social media, which is a popular one. This is also a point where clients will invariably be disappointed. A lot of folks think that if they go out and register a trademark, they might be able to acquire the username on a social media platform. That is not true. The vast majority of social media platforms do not like to force people to turn over usernames unless they absolutely are blatantly infringing on somebody's trademark rights. So it's very, very possible that you have clients that have asked about this because it's a concern. There's a lot of squatting that goes on social media names. But it's also one of the things that we tell clients when you're coming up with a name or you're considering a new business name, new product name or whatever, really go out and secure the social media handles that you possibly can, or at least be aware of what's out there because you're not likely to be able to get them back. So typically if you do register a trademark and then someone starts a social media platform or channel or whatever you want to call it, that's using your client's trademark and using it to either sell competing products or counterfeit products, whatever, then of course you're going to be able to shut that down. And that's the true benefit of the trademark registration. But what you will find is that because there's just such a crowded marketplace and there's so many names floating around out there, you know, if somebody out there was like @Gerben1 and they happen to, you know, be posting about their family, like there's nothing I'm going to do, even though I have a registration on Gerben, there's nothing I'm going to be able to do about that. And so it's just something I have to be aware of. And just from a brand perspective, it's just important to go out and secure whatever usernames you can or things that you think are going to be problematic and make sure your followers know who you are. And just be realistic about it. Again, I don't want to spend our clients' time or money chasing down things that we really can't be bothered with. Not that we can't be bothered with, but we won't have a high chance of success with. What we want to do is focus on those things where there's actual infringement that's going on, meaning that you've registered a trademark and after your filing date, somebody created this page and starts to use it in a way that is nefarious or you know, offering, you know, confusing consumers, offering competing products or services. So that's just something to consider. And there's also a really funny thing that happened here. So squatters are really quick. For those of you that follow me on social media, on Twitter, one of the things that we have a lot of fun doing is when we notice a new trademark filing, I work with a few media organizations, and when we notice a new trademark filing, we sometimes are able to break some news, you know. So in this case, there was a female NHL, the NWHL, was having an expansion team in Montreal, and nobody knew what the name was going to be. So this team filed the name Force Montreal, right? And so we noticed it, we posted it. Well, wouldn't you know, about an hour later or so, this account pops up @Force Montreal, and the actual Twitter bot, I'm not making this up, says, I had nothing to do with this, says, pro tip, if you file a trademark, you might want to save the Twitter account handle at the same time. So unfortunately for this expansion team of the women's NHL and WHL, they filed a trademark application, which we noticed put a tweet out about, and some squatter or enterprising individual, depending on how you look at it, went out and registered the Twitter handle because they had not done so. So this is very practical advice for your clients, but trademark filings are public record. And squatters actually look at trademark filings and then will go out and try to secure things like Twitter handles, Facebook handles, domain names, with the hopes that they're going to then be able to sell it to your client. Because ultimately, if @Force Montreal on Twitter, I mean, I don't know, this is a little blatant. I don't know what Twitter would have done with this. And well, now we have Elon Musk running Twitter. That's a whole other story. But if they didn't put anything ever up on that and they just left it dormant, or they just tweeted about, I don't know, their kids, like it would be really unlikely that Twitter would be willing to hand that back over to the NWHL team. Not to say they wouldn't find a way, or you wouldn't bother Twitter enough that eventually they would turn it back over. But obviously now you've got a major headache when clearly that was available and could have just been secured. So it is an extraordinarily practical tip that if your clients are starting new brands, again, you know, new extensions of brands, new names, whatever it is, hey, are we securing social media handles? Are we securing domains? Is there anything we want to secure here? Because if you don't do it now, you know, somebody might do it for you.
I'm going to hop in here real quick, Josh, with another question from the Q&A. Alyssa asked, do you think a federal law that works similarly to the UDPR could help with this social media issue?
Yeah, it's a good question. So what she's referring to is what actually is going to be next in the presentation, which is talking about domain disputes or UDRPs. Essentially, if somebody, you know, files a domain on something that's very similar to your trademark, you're able to get it back through a legal procedure. That's not actually in federal court, but through an arbitration. You know, I think that would be an interesting way to look at it. You would have to have all the social media channels agree to abide by the arbitrator's decision, which creates, you know, some issues. But I think it's a really interesting question. And quite frankly, given all the squatting that goes on, probably something that would be beneficial in today's world, just again, as an extension of the Lanham Act, which is a federal trademark law, to allow trademark owners to have more recourse, because quite frankly, Twitter, Facebook, all these other platforms, like, they are not incentivized to help trademark owners. That typically doesn't affect the bottom line, these kind of things. And so because they're not heavily incentivized to do it, they don't invest a lot of time or effort into the people that are helping folks like the NWHL team get that name back, right? You might send it, like a lot of times when we're talking to somebody in these platforms, we are definitely not talking to another lawyer, and we are probably talking to somebody, and again, no offense, but that's just not, like, they're just processing a form, right? And so you're not getting a real fair analysis of what's going on. They don't have a lot of people that they're staffing this with. So if there was a federal law, that would arguably help with it, and something that I think it's a very interesting question, and one that should be brought up. And if you're ever talking to a representative out there, you might mention it. Any other questions coming across the hotline? Nothing yet. All right, let's see how we're doing on time. All right, we got about half an hour left. So I hope I've been entertaining so far. Try to keep
Josh, I'll jump in here real
Yeah.
quick again, just to reiterate, if you guys can all check your chat messages, I am separately messaging people that we don't have your full names in the system. If you can just respond back to me so I can update that, that would be great. Thank you.
Yeah, Lacey is very strict. So if we do not get her the information she's asking for, you will not get your credit, and I apologize in advance. But it's not late. Again, it is the state bars. Like, we are told we are subject to audit because we're offering CLE credit. So we are very strict about making sure we have everything we need to be able to provide the credit that we're giving out today. So apologies in advance, but yeah, they're pretty serious about it. Well, Lacey, you just lit up the chat room with that. I see a lot of people in there. So
I did. Thank you all.
that woke some people up. All right. So the next thing that I want to talk a little bit about is the App Store. And this is really, I'm talking about Google Apps, not Google App Store, the Apple App Store. But Google has a Google Play Store. Any of these app stores, kind of the same thing. They are, in my experience, so this is, we've dealt with a lot of clients who have apps and have had infringement issues or concerns with competing apps. And the app stores are very reticent to help you. Matter of fact, it's probably one of the most difficult. Apple's App Store, in my view, this is my humble opinion, is one of the most difficult places to actually enforce a trademark. Because what typically happens is if you submit a trademark complaint to the App Store, they will put you in direct contact with the owner of the other app and say, please work this out. And if you don't work it out and you go back to Apple, many times they will do nothing. So I'm going to tell a story in a moment about something that happened, but it can be a really difficult place, even with a registered trademark, to do any kind of enforcement. One of the things we talk to clients about in the App Store too, though, is the defensive nature of a trademark registration. Because if you own a registration and somebody comes at you claiming they have a similar registration and they're mad about it, it is extraordinarily unlikely, if not impossible, for them to get your app taken down because you own that federal registration, and Apple's not going to overstep that. They would have to sue you in federal court, which is, as we talked about earlier, I mean, that's a much higher investment of time and money for somebody if they're going to sue you in federal court versus if they're just going to try to take your app down with a takedown notice. So one of the things you talk to clients about is, look, even if you're not, because some of the clients will say, no, I don't care what everybody else does. No one's, people know who I am. I don't need to register this or whatever. It's like, fine, but what if somebody tried to take your app down? And that all, and again, we're just trying to, because we've seen that happen. And if you have a registration, it's really going to be helpful. So something to think about in the App Store. I do have, I'll come back to this in a second. I did have a situation once where we, squeaky wheel gets the grease in the App Store too. One of my associates can attest to this, but basically we had a situation where we really needed something taken down. It was really, I mean, it was legitimately infringing. And we went to, Apple put us in touch with the infringer. And the infringer was basically telling us, I'm not going to do anything. I went back to the App Store, no response. Back to the App Store, no response. Finally, I started escalating my subject lines to like extremely important and all these things. And I think every single day for like 2 weeks, I'm probably exaggerating slightly here, but I was sending a lot of emails to the App Store that I got a hold of some email address. Finally, somebody got back to us, and they eventually actually took the other app down. Really took, I mean, a lot of email and a lot of pushing, and we could have just sued them in federal court, but my client wasn't really looking to do that, and we felt that we could just really pester them a lot and hopefully get somewhere. And it did get much further. But I have sent 3-4 emails and got no response, and just goes into the nether. So it can take sometimes it's just a little bit about like, can you catch somebody's eye enough, or can it get escalated internally by what you're saying enough that you're also not being like obnoxious, but you're kind of getting the point across. So it's just a war story from dealing with the App Store. An overarching concept, and this is probably the most important thing. If you're going to take something from my presentation today, please take this, because this is something that I see so much, and I wish clients would buy into this more. When you're protecting a brand in the digital space, a lot of times you're working with folks that are based overseas. When I say working with folks, the infringers are overseas. The people you gotta punch between the eyes are overseas. And if they have set up an account on Amazon India, or they have set up a Facebook account, on a Facebook, one of the overseas Facebook places, your trademark registration in the US is worthless because it doesn't really do anything. They can continue to operate in India, or they can continue to operate in Australia or China or wherever they are. The US registration is only effective on US soil. Now, what we've done in the past, when we've run into this problem and the client has no trademarks registered elsewhere, is you can ask them to block access based on IP address. So for example, I had a case with Facebook where Facebook was willing to block any US IP addresses from a particular account because it was infringing on our client's name, but they weren't willing to take it down. So, there was still an issue. We got some resolution for the client, but not everything. And there was really no legal recourse. Again, our client owned no registration in this other country where we're having the problem emanated from. So it is incredibly important that you think about, especially clients that are operating in digital spaces and selling online or offering services online, that you register trademarks in countries that, one, have a high propensity for like squatters and issues to develop, and two, places that your client might expand to because there's just value there. If you have registrations in other countries, slight side note, if you ever get due diligence and acquired, if the acquirer knows they have the right to operate in these other countries, it creates a lot of value because there's a lot of expansion opportunity for them, perhaps because they have a bigger platform and they can get the product or services into these other countries. But from a sheer enforcement perspective, there's been a number of times where we just, we had a case where the person was in Australia and they were just blatantly infringing on our client's trademark, and this was, and it was something where we couldn't get the platform to take it down. We couldn't even get the platform to block it well enough from a US view. And so it took a lot of negotiation, a lot of twisting of arms to really get something done. And again, so it's, I even had a situation once, and I'll tell you this one more story, which is that we had a client that had a registration in a bunch of countries, but was missing India. And this person was based out of India, was blatantly using that knowingly as a way around our complaints with these platforms. And so, we have a list of countries we like to register marks in when clients give us the go ahead. It's actually a lot less expensive than one might think. I mean, you could probably cover a good portion of the most important countries for, $10,000 or less, if you're doing it, if you're making the filing reasonably. So it's just something we really encourage clients to invest in, because you never know where that infringement is going to come from. And if it's not coming from US soil, good luck if you don't have registration in those countries. Any other questions at this point? All right. Someone brought up domain names. Thank you. This is also one of the places. So, we've just talked a lot about policing on third-party platforms. One of the other things you will see, if you have clients that get very popular, is people are going to start registering domain names around them. I don't even consider ourselves that popular. We had an issue. So I Obviously, domain name for us is gerbenlaw.com. A squatter, will come along and sometimes register, as you'll see here, someone registered a Gerben law firm with an additional G at the beginning. I would have never in a million years thought I should register that domain, but somebody decided to do it for me. And we have, so I have a domain monitoring software that we add, clients that wish to have their domains monitored too. And every day I get a report, and there's stuff in there every day. Some things are actionable, or we want to action. Some things we just know, we can't go after everything. There's a practicality to it. But squatters can do a lot with a domain name these days that really can hurt the customers of your client. One thing is that they might, if it's a common typographical error, like an additional letter, that domain may forward to the squatter's, website, which they're trying to sell a same or similar product. Or it could, in worst case, be like a spoof website where they're asking for your client to log in, or a customer to log into the website, and they're collecting the username and password that they can then go into the customer's account on the legitimate website and do whatever they want, buy things on the customer's account, or do whatever to mess with the customer. They also can use these domains to set up and send emails that look very legitimate. So if you get an email from a domain that looks like gerbenlaw.com, but it has an additional letter in there and you didn't notice that, you could think it's us, and they could be asking you for very specific information that you then reply to, right? So that's a very big concern that, and I always remind clients, I'm like, hey, this might be one we want to go after, because if someone starts sending emails from this address, we could have a problem. So those are the kind of things that we see with squatters and scammers that use domain names to really go after a client's customers. So here's the one that we talked about. So we had an issue with the gerbenlaw.com with the 2 G's. There's other ones that you could see I don't even know we registered these. I probably shouldn't be talking them out loud, but you could see, you could remove a letter and look how similar it looks, right? Or remove words. So these are the ways, you just look through this list here of different ways and different domains. It's a great practice and a good thing for clients to think about, to go out and register some domains that they can think of that would be common for a squatter to go after. Obviously you typically want to go after all the top level domains you can, .com, .net, .org, .us. There's other ones out there now that you can think about. But now there's so many top level domains, you're not going to probably want to invest in them all. So you have to be strategic about it. You look for those typographic errors. The larger the organization, the more effort that should go into this. In some organizations, they will have, you can sit there and have people that really make a list of several hundred, if not 1,000 domains that need to be registered. And because ultimately you're paying like 12, 15 bucks a year, whatever it is. And as we're about to talk about, that's pretty inexpensive compared to what it costs to go after one of these things. So someone asked about a UDRP before. A UDRP proceeding is a binding arbitration. And when you buy a domain name, you are signing an agreement in most cases that you agree to binding arbitration if somebody challenges that domain. So this is beautiful in the sense that it keeps you out of federal court. Again, cost of federal court, typically 10 to 20,000 just to get involved, a lot more once the case starts. If you're filing a domain dispute, or UDRP proceeding, typically, now every law firm is gonna be a little different, but I'd say between $3,500 on the low end and $5,000, $3,500 to $5,000 on the low end. If you're with an expensive firm, it's gonna be like 10 or 15,000 probably. But if you're with that expensive of a firm, you can give me a call. But so it's one of those things where you can make these filings for less than you're typically getting into federal court. And if it's a really obvious squatter, you're gonna win the case. You're not gonna once you make your initial filing, there's not really much else you need to do. The arbitrator will most likely decide in your favor. These are the things you would need to prove up to win the domain dispute. So again, the domain is infringing because it's identical or confusingly similar. There's no legitimate right to use the mark. Again, the idea of having this trademark registration to show that arbitrators is absolutely critical. And the domain's registered and or being used in bad faith. And any evidence of a use of the domain is kind of you don't even need to have them using it in bad faith necessarily, but it is, if they're doing it, it even makes the case even better. So hopefully this slide is helpful to you, but you can kind of see here, the different things you would need to prove up in one of these proceedings.
Hey, Josh, we do have a quick question. What are your thoughts or considerations of renting/leasing your domain versus purchasing one? I don't know if that's a good time to jump in with this now or if it should wait, but
I mean, I'm a big fan of ownership. I mean, I think that if you're renting anything like that, I don't like that at all, only just because, I don't know what the specifics of the situation are. Perhaps maybe it's too expensive to buy the domain, but the idea is you're going to be building value and equity into that domain even further. So you're not going to own it. I don't know. I like that idea. I think it would have to be very specific to a situation that somebody would do that for some reason. But in general, I think ownership is kind of critical. And again, I mean, there could be specifics that would change that, but I would think you'd want to own it.
we have one more question that just came in as well. The
Yeah.
fake client login is worrisome from a security standpoint rather than brand protection, since law firms hold so much sensitive data. What do you recommend as a solution?
Yeah, I mean, I think you have to be aware of any kind of domain squatting that starts to happen. And this is where we get back into domain monitoring. So, every day I get this report that tells me if somebody's registered a domain that's close to ours. And for that matter, other, our the clients that have signed up for this service. And, every day I look at it. And when we've, fortunately, we're not as well known, so we don't really find this often. And you can see on your screen right now, this is an example of something that did happen to us. And you could see that we pasted the decision in there, we little right hook there and we got it back. We're aware of it. We saw it happen, and I spent, I think the filing fee is like $2,000. Okay, so this is not like your legal fees are $30,000, the filing fee is $500. It's like your filing fee is $2,000. So this cost us. We're a small business. That's real money to us, and so it's less for my kids' college fund. But we felt it was important enough because we realized the potential damage that somebody could do with that domain. Given that we're a law firm, we went after it. Now, fortunately, and knock on wood, I don't get this every day. I mean, this is something that happened once in 10 years. So I think the smaller the business, the less likely it's going to occur. But something that you really should be monitoring. And if it's like with your trademark monitoring, domain monitoring, it is the unsexiest thing that we do and the hardest thing to sell to a client, because clients want to acquire trademarks. They think that's, get trademark, that's good, right? Monitor trademark, they think the lawyer is just trying to make a nickel. We're making a nickel, but this reason is because it's really important to do too, and it's just, you're not getting something for it all the time. A lot of times we're sending out reports to people saying like, yeah, nothing to worry about. And if I send that out for like 2 years, sometimes people just cancel the service. And I'm like, yeah, I know there's been nothing to worry about for 2 years, but this is a long game. Like, this is like something will eventually happen. And then, maybe you'll find out about it, maybe you won't, but if the earlier the better. And that's where, sorry, it's a long answer to your question, but doing the monitoring, doing the homework every day, that's how you prevent problems from happening. And obviously, taking all the regular security measures that you can, requiring people to change passwords, requiring two-factor authentication. Those are other things you could start to work into if you have a login system. Anything else, Lacey, on domains?
Nope, that looks like all of our questions so far.
Right. Well, we got 10 minutes left, which is good because I'm running out of voice here, as you can all probably tell. Eric is normally here to help me and spells, but as I mentioned, if you missed at the top of the show, if you've been here before, my law partner Eric Perot is out in Reno, Nevada, claims he's not having too much fun, and at a board game conference, because he likes board games and every board game owner has a trademark. So it's a good place to be, but he left me alone today. And really what we did is we did not pay attention to the schedule when we made this presentation for today. So next time we will, because the older I get, the harder this is for an hour. All right. The last thing I want to talk about today, Web3. We've all heard about Web3 at this point, I would presume, unless you've been living under a rock. This refers to new technologies such as NFTs, the metaverse, which I'm still bullish on, blockchain technology, cryptocurrencies. So what's the problem with the metaverse and trademarks and brand protection? Well, existing trademark registrations were actually not typically filed broadly enough to cover all the applications that could exist in a new Web3 environment. One of the great examples, a couple of great examples would be Nike. Picking on Nike a lot today, but I know issues with Nike. This was an article that CNBC ran about how Nike is preparing for the metaverse, talking about how it filed new trademark applications on all of its trademarks for new products and services. Specifically, Nike filed trademarks to cover the idea that they were going to offer digital products, like a digital shoe, that they were going to offer a metaverse environment, a digital environment where people could come and network and talk and hang out, and all these kinds of things. So their previous trademark registration for Nike never contemplated a digital product because it just wasn't ever something that really people thought about, or it didn't contemplate a metaverse like store or a metaverse like hangout, or whatever else you can offer in the metaverse that in real life just wouldn't be practical. We have had many clients who have filed new trademarks for existing brands because they'll say to me, well, look, we have this wine product, but we're going to offer digital wine. And when I say digital wine, what they're talking about is, if you're not familiar with these environments, like you go into them and you can actually buy like a Nike shoe and wear it around. And, the younger, the kids these days, especially my kids, they really like this. I don't find much value in walking around the metaverse in a pair of Nikes, but it's a thing. And so the idea that you're gonna put that brand out there, and it's going to be a great branding opportunity because people in the metaverse, if Nikes are cool in the metaverse, they're going to be cool in real life, and people are going to buy them. If you want to brag about what you're drinking in real life, you might go in the metaverse and carry around the digital product, and talk to your friends. So we'd have a wine brand, for example, that would go and say, hey, we need to file a trademark to cover the idea that we're going to have this hangout place, that we're going to sell digital products, we're going to have NFTs, because NFTs is a big one just because it's basically like the new customer loyalty cards, you can really track a lot of things with them. So there's all these different applications that brands did not presume when they filed their trademark for wine, and that's where we're advising clients on a lot is, hey, look, I know we're in the crypto winter and, NFTs were a fad and now they're no longer a thing. But you really do want to, this is probably still coming. We just, it's going up and down, but it's probably going to be here. And you really want to do an audit of your existing trademarks and make sure they're protected for these things. If they're not protected for these things, somebody else, again, could have, you can think about, for example, two companies. Think about like Dove chocolate and Dove soap. Both own trademarks on Dove, one for chocolate, one for soap. They've been allowed to coexist or worked out coexistence. Well, what if they both filed Dove for a metaverse hangout, right? Now, who's the rightful owner? It could create, so you want to be first, you don't want to be second. And a lot of companies have this issue where there's other companies out there that share a name, just happen to be in a completely different industry, but now both companies are filing trademark applications for NFTs. Both companies are filing it for the metaverse platforms. And you have a priority issue that develops if you're the second one to the party. So the earlier that clients file these applications, especially so long as they have an actual intent to use them for these applications, certainly the better, and something that is very highly recommended by us. Again, clients may think it sounds self-serving, but for the ones that get stuck in second place, meaning the people that beat you to the punch with a similar name, you could be spending tens of thousands of dollars in litigation or enforcement or defense costs that could have been obviated by just having filed the application first. So it is a little bit of penny wise, pound foolish not to get these applications filed at this point.